Okay, looks like we've got all our attorneys here. Put us on the record, please, Shannon.
Go ahead.
Okay, in the matter of Cameron Bliss and the Schuler and Harrington minors, a pretrial was conducted with attorneys only in chambers. Both cases remain scheduled for trial. There is a potential for adjournment, but we're going to keep them on for now.
They're on as jury trials. So am I changing that to a bench trial?
No, just keep them on. We'll see what happens. Okay, Taylor Hamby. I'm going to let Ms. Bowen in just briefly to let her know.
Okay, thank you, Your Honor.
Ms. Bowen, we did pretrials in chambers on the Harrington, Schuler, and Bliss minors.
Oh,
we're going to keep the trial. We're going to keep the trial dates on with the potential for adjournment.
Okay, perfect. Thank you.
You're welcome. Okay, next up is King Hamby, and let's see. There we go. All right, now let me see. I see Mom is here. Let me let her in. And are we expecting? I think that should be everyone. Could everyone identify themselves for the record, please?
Matt Way, Prosecutor's Office.
Rebecca McCluskey, Guardian Ad Litem.
Do we have a worker?
Dante Conley, Family Community Services Foster Care Worker.
Ivan Brown on behalf of Adriana Taylor Hamby.
And Ms. Taylor Hamby is present. Okay, Ms. McCluskey, how's King doing?
He's doing very well. I'm happy to see he's in his placement. There are no issues. I don't have any concerns. And placement doesn't report any concerns with King either. I've reviewed the report. I don't have any objection to the recommendations. I'm just I'm glad to see parenting time is suspended at this time, with considering the circumstances. Thank you, Your Honor.
And Mr. Conley, do you have any updates or additional information for the court?
The visits haven't been suspended just of yet. We were asking for them to be suspended due to King's due to Adriana's behavior, basically, and his safety. She has made a couple of threatening behavior statements, stating that she would grab a gun and go to the resident's home to retrieve him. So we did ask for that. Other than that, King is doing okay. He's doing fine. There were a couple of
okay, I'm trying to figure out where did because I was trying to get it. I don't even know how this work.
There were a couple.
We lost Ms. Hamby briefly, and I just
I don't
even
know how to mute it. I'm trying to figure it out. I'm trying to figure out how to work this.
Can you hear me, ma'am?
Yeah, I hear you now.
All right.
What am I supposed to do here?
You're just supposed to listen, ma'am. Okay. Mr. Brown, what is your position on the recommendations?
Judge, we adequately oppose any suspended parenting time. We think adequate safeguards can be put in place for supervised parenting time. If there are actions that the department deems inappropriate, they can determine that at the time. Further, we would ask that just give another report period. I know the agency is requesting termination of parental rights, but I would remind the court, that last time Miss Taylor Hamby did wonderful. If she can engage and get her shot, she did wonderful. Thank you.
Can I talk?
Your Honor, I'm sorry, I can weigh in if the court doesn't mind. I apologize. From speaking with placement and the caseworker throughout this last reporting period, I thought for some reason we had gotten parenting time suspended. I know that placement had to get law enforcement involved. Maybe that she has a PPO. And I think threatening to come to placement's home with a gun and retrieving the child is probably basis for suspended parenting time. I usually agree with Mr. Brown's position, but and this is, yeah, and this is challenging because I agree with Mr. Brown. Ms. Taylor does very well when she takes her medication, but how do we make that happen? So, and I do support a goal change. Thank you, Your Honor.
All right. Ms. Hamby, I'm going to unmute you now so that you have a chance to talk.
Okay. I just want to start off, and I can talk now. I've been doing the stuff they asked me to do. I don't have reliable transportation. And when I do ask for parental time, I have to find a way to 18 Mile and Gratiot somewhere or Van Dyke. And that's very far from my living. They in Macomb County. Why I can't get a CPS worker in Wayne County where I resident at? Because I'm not a resident of Macomb County. And it's hard to go on 8 Mile and Van Dyke. It's like they didn't transfer the case to the right county where I reside in now. So why do I gotta be in Macomb County and Van Dyke and 18 Mile if I live on 7 Mile and right here on 7 Mile, Wyoming, in Wayne County? The CPS worker is not even trying to help me in the leeway so I can try to start these classes. I asked him a lot of things or questions about these parenting classes he signed me up with. He don't even know what to do or say. I just got to keep calling these 1-800 numbers. And it's very hard when I try to call these 1-800 numbers because it's always a automatic machine. He tell me my parenting times have to be at that office, but I cannot never make it there on time because it's so far. And I'm not trying to catch the coronavirus on a Detroit bus because the bus drivers cannot talk to the people because that's why they stopped their buses because the bus drivers got beat up. So now if I try to catch the bus to there, it's a 50-50 chance that I will catch coronavirus and pass it to my son during my parenting time. And he told me there's nothing else that I can do. I better do it. I gotta catch the bus. Or he's not working with me at all. I'm trying to get a chance to work with him, but what's he say goes. He's not trying to provide me with no type of whatever. Is just do it or you don't do it at all. I'm begging for some type of other type of help. He won't change the case to Wayne County. He won't give me some type of can we meet in another public place to have my parenting time. I ain't seen my son since the beginning of this year, since this case been started. Since this case been started, I have not seen my son. My grandma asked me that I want to come over to see my son. That's how that got started. I called CPS on my grandma. My grandma had them people pull a gun out on me. I got a police report for that. I got evidence that these people tried to jump me because I called CPS on my grandma because my son said that she beat him with a stick and I got it on video and he told me that he was scared to go back in that house. This not the first or second time he got harmed out of my care when y'all took him out. He got burnt in the face the first time. Now the lady beating him in the head.
All right. Well, this is not the time for a trial. It's a review hearing. I've heard enough.
Help the leeway when I try to do these.
I'm going to grant the goal change. I'm going to suspend parenting time. We will set November 17th at 8:45 for receipt of a termination petition, and I'll schedule a trial at that time. In the meantime, I'll schedule a review hearing for February 2nd at 8:45. Thank you all.
Judge?
Yes.
Review hearing. Review hearing 8:45 also?
Yes.
Okay, thank you.
February
Thank you.
2nd. Thank you.
I never abused or neglect my child under your false allegations. That's rude and disrespectful.
Okay, next up is Riker and Remington Lewis. There's Miss Tennant. And parents' names, let's see, we've got Jonathan Lewis. I don't see him.
Dakota
And what's the
Densmore.
mother's- Densmore.
They're usually together, I think.
And he works. He hasn't been showing up a whole lot for hearings.
All right, I've got a bunch of folks in here that are devices, so I have no idea.
Ms.
I'm
Tennant, do you
just
know
gonna
if the parents were going to participate?
I don't know for sure. My inclination is both mom and dad are potentially working. So I don't know if they were even available. I haven't spoken to them specifically about being here.
Yeah, I'm just gonna let everyone in. There's so many in there today that don't have identifiers. If I have trouble with anyone, I'll just boot them out. Yeah, I'm just gonna let everyone in. There's so many in there that don't have identifiers. If I have trouble with anyone. All right, somebody's got a YouTube playing. You need to turn that down. Okay, so this is the matter of the Riker and Remington Lewis minors. Can I have everyone on this file identify themselves for the record?
Matt Wade, Prosecutor's Office.
All right, somebody's got a YouTube playing. You need to turn that down.
Beth Tennant with Family Service and Children's Aid.
Mike Kelly on behalf of the mother.
Rebecca McCluskey for Jonathan Lewis.
Ivan Brown, LJL.
And we have either parent present. Okay. Mr. Brown, how are Riker and Remington doing?
Judge, they're doing extremely well. They're in the custody or care of their grandparent and great-grandparents. They're wonderful people, have a nice home, very doting on their grandchildren. I talked with them. They're in support of the recommendation. However, they have never been ones to mince their opinion with regard to their son and grandchildren. That they're concerned that they're not totally ready for FRP and the children to come home full time. They're not consistent. They call them. Sometimes they'll call them a dozen times. They don't answer, don't call back. Something could be wrong with Riker or Remington. They don't show up on time. They're saying they're not showing the kind of responsibility that they think they need to show to have them back full time. But I will, and I echo those concerns. If they're going to have them full time, they need to really step it up. But they've done well in services, so I'm pleased with how they've done in services. But when it comes to dealing with the grandparents, I think they lean on them too much, and that's a concern to them. Thank you.
Ms. Tennant, can you address those concerns?
Yeah, I have spoken with placement quite a bit about some of those concerns as well. And it's kind of a tricky situation because I do also see some of the, I guess, lacking communication between the parents and placement. Overall, they have been more consistent with parenting time, and they've always been consistent with their services. So for that reason, I still feel like it's appropriate to move forward towards reunification. I don't have any concerns about their time and their interactions with the children. So I guess for all of those reasons, I think it's time to move forward, just given the amount of time that the case has been open. So that's kind of my position.
Mr. Kelly.
Your Honor, we forget these parents are 20 and 21 years old. I'm not sure many of us at that age trying to maintain a home, working full-time, or not otherwise going to depend on family. It's a little bit disappointing that the grandparents have essentially stated the concerns that they have, but they are family, and I think it's one of the support people that mom and dad are going to rely on, and I don't think it's rises to the level of us having to delay this case moving forward because they are relying on family for assistance. I'd imagine if they had better financial means, they may not have to rely on family, but it is what it is. So I'd request of the court to adopt the recommendations, and would look forward to FRP participating with this family. Thank you.
Ms. McCluskey.
Your Honor, I agree with both Ms. Tennant and Mr. Kelly. And I am aware that these parents do have kind of an extended family that's a support system, and I think they're great supports, but they probably are a little judgmental toward these parents. And like Mr. Kelly said, they're very young and they're juggling a lot. And at this point, as Ms. Tennant also stated, they've done everything. There have been no mishaps with these parents. So I would also ask that the recommendations are adopted. Thank you.
I would note that the work also.
So Ms. Tennant, I know in your report you're engaging FRP. In your recommendations, you didn't specifically ask for discretion to return the children home with FRP services. Are you asking for that discretion this reporting period?
So we actually already had discretion at the last reporting period. We were just waiting to move forward with that. So within this last reporting period, I made that referral, and they have already been engaging with FRP and doing very well. And so we have a return home date at this point of November 11th.
All right. Well, because you didn't include it in this list of recommendations, it has to be in my order that you still have that discretion. So I'll make sure that's included.
Thank you.
Okay, I will grant the requests. I'm not deaf to Mr. Brown's relating the grandparents' concerns. I realize that grandparents, parents of parents, and grandparents of their children are sometimes more exacting in what they would expect to happen compared with what the court would expect in terms of the minimum necessary in order to see reunification take place. I'm not insensitive to those concerns. I would hope they would understand that our goal here is to reunite these children with their parents, and would hope that they would be supportive of that. So I'm going to implement these recommendations. We'll set our next review hearing for February 2nd at 8:45. Thank you.
Yes, and I would note all my affidavits were put in the mail this morning.
Thank you.
Yep.
Okay, next up is Xavier May. Can I have everyone on this file please identify themselves for the record?
Manaway Prosecutor's Office.
Lindsay Cooling, DHHS Foster Care Case Manager.
Ivan Brown on behalf of Alicia Tedder.
Ken Hotchkiss, LGAL.
Then I can't tell if Ms. Tedder is present or not. We've got a lot of telephones and
Ms.
devices logged in.
Ms. Tedder no longer participates in the court hearings.
Okay, very good. Mr. Hotchkiss, how is Xavier doing?
Honor, Xavier's doing very well. I spoke with the paternal grandfather. He's adjusted very nicely. He's been in that home for quite some time, over a year now. My understanding that they've done what they need to do to complete the guardianship. The caseworker may have other information, but he was expecting that the guardianship might be available for review and maybe presentation to the court next month. The only issue that was reported was that I guess the mother had a couple of weeks ago tested positive for COVID, and so the visits have decreased, or they're at least waiting till the appropriate period passes so that they can continue. But he continues to do extremely well. Thank you.
So Ms. Cooling, are we ready for the court to check the box for you to obtain make sure we have a home study that's less than a year old and a current criminal and background check?
Yes, Your Honor. So I actually received the documentation from the subsidized guardianship office, and placement signed it. It was sent back to them via mail last Thursday. Once I get that final documentation, we will be able to move forward with the guardianship with the courts. So I would ask that you can check those boxes.
Okay, find them. Here we go. And Mr. Brown, you represent Ms. Tedder. Any objection to the recommendations?
I would have no comment.
All right, I have checked those boxes, and we will, I'm going to set a 3-month review, but Ms. Cooling, if you get that approval, just get a hold of Shannon and ask for an early hearing so that we can get the juvenile guardianship documents in place and keep this moving along.
Absolutely.
Subject to an earlier hearing, we're going to set a review hearing on the record just in case for February 2nd at 9 a.m.
Thank you.
Thank you.
Thank you.
Going out of order, we're gonna call the person.
This one? Okay, next up, we're going to do the Highland Allard and Patrick minors, because I have to make a prison call. I'm going to do that now.
You have reached the Carson City Correctional Facility. If you are calling from a touch-tone phone, press 1. Please dial the 7-digit phone number of the person you wish to speak with, or you may dial 0.
wait while I transfer your call.
Hello.
Good morning. This is Judge LaFlamme.
Good morning, Judge.
And I'm looking. State your name, please.
Dustin Highland.
Okay, Mr. Highland, sorry, your name wasn't on the same sheet of the phone number that I was dialing, so. All right, can I have everyone else on this file identify themselves for the record?
Matt Way, Matt Way, Prosecutor's Office.
Lindsay Cooling, DHHS.
Ken Hotchkiss, lawyer, guardian ad litem.
Mike Kelly. Kelly on behalf of the mother, Miss Patrick.
Ivan Brown on behalf of Dustin Highland.
So, Mr. Hotchkiss, how are these children doing?
Well, as the court knows, Your Honor, Gabrielle has been with the maternal grandparents, and we're waiting on a guardianship. The three youngest were placed back with the grandparent in late September because of a relapse by mom. It's a setting and an environment that they're very familiar. They're doing very well. The maternal grandmother reports that the kids are very active, obviously keeping her busy, but they've adjusted into the home. She has indicated that mom is currently waiting on the results of a COVID test, so there's been no in-person test or visits. So, but other than that, everything I guess is going very well in that house at this time. The only issue that I think, and the caseworker I'll let address this, but maternal grandmother's requesting permission to sign for medication related to Gabrielle. And I know that that's been discussed with the caseworker. So I have no objection to that when the court considers that request. Thank you.
And is the mother present?
Your Honor, I don't see her present.
All right, I've got a couple more people just signed in. Let me see.
Is the petition to sign for the other kids for a guardianship too?
No, it's just for Gabrielle.
Okay.
The request was to be able to sign for medication while we're waiting for the guardianship.
Oh, okay.
All right, we've got one more connection to be made. Let me see who this is. Or see who it isn't. All right, do we have, I'm sorry, Mr. Kelly, what's your client's name?
Miss Patrick.
Is Miss Patrick present? All right, apparently not. Okay, so, and I've lost track of who the worker is on this file.
Me.
That's what happens when I let everybody in. Ms. Cooling. Okay.
Lindsay Cooling, I think.
Yes, Ms. Cooling, do you have any updates for the court?
I do. We are still waiting on the subsidized guardianship initial approval to come back from the guardianship office. Once we receive those, we will have Tony and Carson Patrick sign those, who are Gabrielle's grandparents. We are asking that Tony and Carson Patrick are allowed to sign all consents for Gabrielle moving forward as that relates to school, her therapy services, and through Lifeways, due to them pursuing guardianship. And Gabrielle and her mental health feels more stable if her placement is signing that consent instead of her birth mother, Danielle Patrick. Overall, the children are doing very well in Miss Patrick's home. Miss Patrick is currently waiting for COVID test results to come back for her to have visits with the children. So she has not been able to participate in any drug screens or any in-person services since the 19th of October.
Okay, and Mr. Brown, do you have a position on the recommendations?
Well, we're glad that the children at least have a grandparent and they're not in regular foster care. Hopefully, Miss Patrick can get her substance abuse under control. I do note that Mr. Hyland's earliest release date is approaching a year away. We're just thankful that they're with the grandparents, and hopefully Miss Patrick can get things together. Thank you.
And Mr. Kelly.
Your Honor, my client indicated to me when I spoke to her yesterday that she went tax through Odyssey House and is now in IOP. They're, of course, with family, and she about the COVID issues. So hopefully that can get remedied so the parenting time can continue. I have no objection to the recommendations. Thank you.
And Mr. Hyland, did you have any other questions for the court?
No, sir.
All right, I believe all of the recommendations are appropriate. I will implement them. That will include granting placement, the ability to sign any consent necessary for Gabrielle. We'll set our next review hearing for February 2nd at 9 a.m. Thank you all.
Thank you.
Thank you.
Thank you.
You're welcome, Mr. Hyland. That concludes our hearing. Have a good day.
You too.
Where's mine?
Okay, next up, Michael and Serena Cox. Can I have everyone on that file, please identify yourself for the record?
That way, prosecutor's office. I believe Ms. Hines is here for the agency.
Deborah Hines, DHHS, sorry.
Ivan Brown on behalf of Kenneth Cox, father.
Rebecca McCluskey, guardian ad litem.
Okay. Ms., do we have either parent present?
Mom is a non-respondent.
I don't see Mr. Cox on video. I'm not sure if he's here via phone.
Well, he hasn't identified himself as if he is, and there's nobody in the waiting room. Ms. McCluskey, how are Michael and Serena doing?
Your Honor, I left a message for Mom, and I was not able to reach her. I did review the court report. I'm glad to see Dad, Mr. Cox, appears to be doing pretty well. So I have no objection to the recommendations. Thank you, Your Honor.
And
oh, I was, and I can't remember.
Ms. Hines, sorry. Go ahead, Rebecca.
Oh, I apologize. I meant to ask Mr. Way if Dr. Henry's report came in, because I thought I had seen that, but I couldn't find it.
It did.
Okay.
I have not seen it. I just saw a reference that it was that it had been completed and that we were waiting for the report. I have not yet seen the report.
Okay.
Yeah, Dr. Henry's
Mr.
report.
Way,
sorry.
Oh, sorry. Go ahead. Go ahead. Yeah.
The CTAC report is not completed yet. He did the assessment, but they haven't done the report. They're trying to get Serena scheduled for this Friday and then do them both together. The psychological for Mr. Cox, though, was completed and provided to the court.
Yes, that I have seen and I have read. Ms. Hines, do you have any other updates for the court?
I don't, Your Honor.
And Mr. Brown, what's your position on the recommendations?
Judge, the reason why I thought the recommendation, the trauma assessment was done is because there are references to the trauma assessment in the reports that indicate how Mr. Cox interacts with his children. And in the report, it indicates that Mr. Cox, his interactions and how Michael interacts with his father is much better. Are we done with that?
I muted. I muted the source.
Mr. Hotchkiss.
Wasn't me.
And it indicates that his interactions with the child are much better than with mom. We asked for unsupervised discretion and unsupervised parenting time, considering the progress that he's making. I realize that housing is still an issue for Mr. Cox, but he seems as though he's making progress on that even. And also in the psychological, it asked for a neurological medical workup for Mr. Cox to see whether there's something that is limiting him, but I don't see that in any of the recommendations. I just wonder why we're just glossing over that. If we're going to do a psychological evaluation, why aren't we heeding what's in there? If Mr. Cox needs additional help, we need to provide it. And if we're going to do a neurological, those take forever to even find somebody to do something like that. So I think that needs to be added. Whether can be given. Thank you.
That's one of the dangers of letting everyone in. We get interruptions from multiple sources, but it's just hard to tell who everyone is without doing this. So I did note in the report the reference to Mr. Cox having a better ability to regulate Michael's behaviors than the mother does, which is concerning. It looks like at least until CPS intervened, Mr. Cox was able to get his son's attention by a strong hand of physical discipline that frankly went too far. And it looks like perhaps we've got a mom that doesn't know how to regulate the child's behavior without dad around to help. That looks like something that definitely needs to be explored. I'm assuming, Ms. Hines, that you received that orally from the CTAC?
Yes, Your Honor. I was there for both of the parent observations and spoke with Dr. Henry after both of them, and he gave me that information. And it is, those things are going to take time. Mr. Cox has been here before and we've serviced him. I want to make sure that we are taking that time with him and servicing him via ADA. The neurological, we don't believe that it's going to tell us anything different than what we know now, as far as limitations and the way that we should work with him and provide him services.
Well, Judge, we have a PhD recommending that. I guess I don't know why the agency would think they would know more than a PhD doing the psychological evaluation and the trauma assessment. Why have it then if we're not going to follow through on their recommendations? I'm dumbfounded.
Well, as I read that recommendation, he makes the recommendation to identify the underlying causes of what appeared to be mild to moderate cognitive impairments. I guess, Ms. Hines, you could certainly talk to Dr. Rickman to see, is this going to help us in addressing his cognitive shortcomings? I mean,
Right, Your
if
Honor.
if it's going to lead to something that can improve, it's worth knowing. If it's a medical curiosity, excuse me, a medical curiosity as to why he is the way he is, I agree. It's why spend the money on that? But if knowing those reasons can actually help us address the behaviors or shortcomings that are a result of that, then I would support that. So, Ms. Hines, I think you need to follow up with Dr. Rickman to find out why he made that specific recommendation and whether or not it's going to help us in the services that are provided to Mr. Cox. I want to make sure it's not simply intellectual curiosity as to why he is the way he is.
Your Honor, I did speak with Dr. Rickman after the psychological because I transported Mr. Cox there as well. And he was saying because Mr. Cox wasn't describing how any early on childhood head trauma or any cognitive delays, that Dr. Rickman was curious as to where those limitations were coming from. I can follow up and have a conversation, but it is difficult to service cognitive delays or impairments.
Yeah, and that's, again, just follow up and make sure, are you just curious about this, or can it really lead to some concrete assistance that could be provided?
Sure.
If it's just curiosity, we're not going to waste our time with it.
Okay.
Judge, I would ask that be put in writing, because I highly doubt that a psychologist would put, I recommend a medical neurological, just out of his plain curiosity, if he didn't think it would help. That goes against all medical intervention. So I would ask that it be put in writing and disseminated to all parties, his thoughts on that issue.
That's fine. So if you could follow up and ask him to identify in writing what value that would have to addressing the cognitive concerns.
Sure.
Again, Judge, we would ask for limited unsupervised parenting time.
Doesn't the psych eval also recommend supervised parenting time? I don't think we can have it both ways, where we're going to completely rely on the psych eval and then deny that. And then I read the counseling reports, and the counseling reports to me are concerning. He's still having, I don't know if I'd call it outbursts, but he's having issues regulating his emotions and his behaviors. And given what the previous allegations are, I would not at all be comfortable with supervised or unsupervised parenting time until we get that under a little more control.
These weren't instances where he broke bones. He left a handprint on his child, which is bad, but nothing that is out of the way where he was putting the child in terrible harm's way. So I don't want to minimize, nor do I want to overblow the situation.
I'm not ready to grant unsupervised parenting time. I will grant discretion for unsupervised if he makes progress and there is no concern for the well-being of the child based on the progress that he's made, but I'm not going to compel it.
Thank you.
Thank you.
Thank you.
Okay, our next review hearing will be February 2nd at 9:30. Thank you.
Thank you, Your Honor.
And next up is Dakota Johnson.
Morning, Your Honor.
Can I have everyone, I just let a bunch of people in. Hold on a second. Make sure they're all here. All right, can everyone who is present for the Dakota Johnson review hearing please identify themselves for the record?
Matt Way, Prosecutor's Office.
Troy Jennings, Jackson DHHS.
Ronnie Johnson, Dakota Riley Johnson's father.
Cynthia Chamberlain, foster parent / grandmother.
Rebecca McCluskey for Ronnie Johnson.
Mike Kelly on behalf of the mother.
Ivan Brown, LJL.
Okay, let me hear from Mr. Brown first. How's Dakota doing?
Wonderful. Dakota's with all of the siblings that are in the care of Miss Chamberlain, the grandmother who's with us today. I spoke with her, I believe, Friday, and everything's going very well. She's in support of the plan, and I am in support of the plan also. Thank you.
Thank you. Ms. Jennings Ms. Jennings, do you have any updates to your report or any changes to your recommendations?
I do have some updates. Ronnie did provide proof of employment to the agency, and Ronnie has missed 2 video call parenting times since the report was written. For Dana, I was able to complete a house assessment with her. There are no physical issues like safety issues with the residents, but there are concerns related to the stability of the housing situation since she's had a pattern of living in places that are not stable. And right now she's dependent on this housing with her significant other.
And you are still recommending a goal change?
Correct.
Okay, Ms. McCluskey, what is your position on the recommendations?
Thank you, Your Honor. I was not able to speak with Mr. Johnson. The number I have was not accepting calls. It's also the number in the court report, but I did review the court report, and I noted that actually the only issues that appeared to be related to Mr. Johnson were housing and employment. It sounds like from Ms. Jennings' update, the employment is no longer an issue, that he is employed. So we're just looking at housing. The court report references that he's fully engaged with services and has been. And I know Ms. Jennings did just reference two missed parenting times. I would ask her if there are any reasons for those, because I'm having a lot of parents miss parenting time due to either placement being sick, the children being sick, the parents being sick this time of year. So I'm hoping that we're not throwing those missed parenting times in and not explaining why, if there's actually a reason. So I would ask, obviously we are just short of a year. Dakota's been in care, well, just short of 11 months now. So we would object to a goal change and ask for at least one more reporting period because Mr. Johnson is engaged. Thank you. And Ms. Jennings, were there reasons for the two missed parenting times?
We do, because he's in Georgia, we do video call parenting times.
Oh, I'm sorry. Yeah.
He had said that the first one was because his alarm didn't go off, so he missed it because he was not awake. And the other one he said that he was running late and he wasn't able to get on. And he didn't tell me these until after.
Okay. Gotcha. Thank you.
And Mr. Kelly.
We'd echo the sentiments of sister counsel and just indicate to the court she was making progress with therapy when she was available, and she started a new med in October, so hopefully that assists as well. And indications are from the training, coach or the instructor for the parenting classes, she was engaged and scored higher, showing her improvement in understanding of the materials. So I had nothing else to add, Your Honor. Thank you.
All right, thank you. I will grant the recommendations. I think a goal change is indeed in order based on the lack of progress and the amount of time that Dakota has remained in care. We will set November 17th at 8:45 for receipt of a termination petition, and we'll schedule a trial at that time. In the meantime, we'll set a review hearing for February 2nd at 9:30. Thank you.
Thank you, Your Honor.
I'm sorry, I missed the date to accept a petition.
November 17, 8:45.
Thank you, Your Honor.
You're welcome. Okay, Peyton Wireman and Nakia Westman. Can everyone present on this file please identify yourself for the record?
That way, prosecutor's office.
Jackie Johnson, DHHS.
Rebecca McCluskey. Sorry, Shinka. Rebecca McCluskey for Kristen McKay.
Ken Hotchkiss on behalf of Nicholas Westman.
Yeah, I'm sorry. We had two people talking at once. Who else had stated her name?
Ken Hotchkiss.
All right, now we had it again. Hold on.
It's Sharmika March with the agency.
Thank you.
Ivan Brown, LGAL.
Mike Kelly on behalf of Mr. Wireman.
Ken Hotchkiss on behalf of Nicholas Westman, if you didn't get that yet.
All right, and Mr. Westman is present.
Yes, I am.
And do we have any other parents present?
I'm here, Kristen McKay.
Okay, thank you. All right, Mr. Brown, how are these children doing?
Judge, they've continued to be in the maternal aunt's home since the inception of this case. They're doing wonderful. The maternal aunt is highly qualified medically to care for Peyton. And I think she does a phenomenal job with both children. I am in favor of the recommendation with a caveat. I just, what we're asking is to terminate the parental rights with regard to mom and dad as regard to Peyton, and terminate mom with regard to Nakia Westman. I would rather not do them at the same time. I will never, Mr. Westman has not been in Nakia's life for a year and a half, 2 years, and now shows up. I'm glad that he's doing well.
Been about 9 months.
Hope that he realizes the trauma that would cause to be ripped away from his aunt, who she's looked to for over 2 years. I don't think her best interest I can ever support. So I will leave that up to the court how they want to proceed procedurally. But I just, it's confusing, and I would rather do it at once if we're going to do them. Thank you.
I think there's a change to that recommendation, Mr. Brown.
All right, let me, given that, let me hear from Ms. Johnson. Ms. Johnson, do you have an update for the court?
Yes, sir. We had an FTM and I went over recommendations with Mr. Westman. I went over recommendations with Ms. McKay. I had an FTM scheduled with Mr. Wireman. He did not show up, so I wasn't, but he did receive the report. I can update you that Ms. McKay did indicate she has been doing her drug screen, so I contacted EverHealth and double checked. She has been doing the drug screens. She did test positive for meth in September once. The rest of the time she has been clean of any hard drugs, with only positives for marijuana. When I met with Ms. March, we left the recommendations the same, recognizing that perhaps the fact that she was attending the substance abuse screens would, the court and her attorney might have a different take on that, but we were still going to leave our recommendations the same. Mr. Westman has completed a substance abuse assessment and with Family Services and Children's Aid, and they have indicated that he does not meet the criteria for a substance abuse diagnosis or treatment. So we'll be continuing to pursue a psychological on him, and not, our recommendation on him is that I would continue to have him do drug screens, but on a less frequent basis in case a problem does pop up again.
Thank you. Mr. Hotchkiss?
Honor, I did discuss the report and the recommendations with Mr. Westman. He's committed to the service plan. He wants to be reunified with Nika, and it tells me that he will do whatever the court requires of him. So we would certainly ask the court for that opportunity. Thank you.
Thank you. Mr. Kelly?
Your Honor, I've had no contact with Mr. Wireman. I attempted to call him and left a voicemail at the only phone number that I have, and I have not received a return call, so I have no comment on the recommendations.
And Ms. McCluskey?
Thank you, Your Honor. I also discussed the court report with my client. I guess I'm confused as to how such a large mistake could be made as to the drug screens. I would imagine the agency actually does confirm that information with the provider. So I'm not sure what happened there, but I'm glad that Ms. Johnson corrected that information. As for the alleged missed parenting times, my client indicated that she had a medical procedure, so she had a healing process, which resulted in some of the missed time. And this is the situation where placement was ill, I believe, and the children were ill, so those face-to-face parenting times were actually canceled. So those were not at the fault of my client. So I really wish the agency would add those explanations in when they indicate some missed screens or missed parenting time. As for everything else, my client she's actually participated and completed all of the services that were asked of her. She completed the substance abuse assessment. She's doing well medically. The court report references that her home is family friendly and appropriate, and she's employed as a home health aide. Excuse me. So I don't see any substance that would support a goal change as to my client. So we would object to the goal change. Thank you.
Your Honor, may I add a few things?
Go ahead, Ms. Johnson.
Miss McKay did go to a substance abuse screen at Family Services and Children's Aid. She attended 2 appointments. She missed 2. She received she was sent a letter to contact them or her case would be closed. Her case was closed. I asked her to contact them and get reconnected with them. The second, the appointment or parenting time that was referred to in terms of everybody being sick was not included in this report because it happened after the report was complete.
Thank you.
Thank you, Ms. Johnson.
Given the disclosure that in fact mom has been testing and except for one instance testing negative for anything other than marijuana, which frankly I don't encourage at all. I think if you're going to be a good parent, you can't be relying upon any kind of mood altering substance, whether it's legal or not. But with the fact that we're heading towards reunification with Mr. Westman, I mean, if we were looking solely at Mr. Wireman, that'd be an easy decision, his lack of engagement and involvement. But I think it's premature to be ordering a goal change. I typically do not terminate parental rights for one parent when I have another parent who's actively involved and engaged. I might do a custody order if there's no progress being made, but I typically do not terminate. So in light of the new information about the drug screens, in light of the fact that Mr. Westman is engaging and moving towards unsupervised parenting time, I think a goal change just for Mr. Wireman at this point is not going to speed up the process with respect to the other parents. So I'm going to deny the request for a goal change now. I will tell you, and Ms. McKay, I hope you're listening.
Yes, sir.
It's been a long time. We need to move forward. There can't be any more hiccups. You have to stay fully engaged, fully committed, if you want to have any chance of preserving your parental rights and be unified with your children. I'm going to set a review hearing for February 2nd at 9 a.m. I'm implementing all of the recommendations with the exception of the goal change.
Your Honor, one other question. Peyton has an appointment in Cincinnati on November 23rd. And can we get permission to take her out of state now, or do we need to submit that closer to the date?
Anyone wish to weigh in on that request?
I'm in agreement with that. I spoke with Ms. Oberline, and she was going to try to get that appointment done via telemed. But if that can't be had, I'm in agreement that she be allowed to take her to Cincinnati for that necessary medical appointment.
And can the foster parents sign the consent if Ms. McKay is not able to go with them?
Ms. McKay, do you consent to that trip for the medical procedure?
I do, but I've already got it scheduled off of work to where I can go with Aunt Debbie and Uncle Larry.
Okay.
Like, I'm fine with them signing it, but I would like to be there if possible.
I will grant permission for Peyton to be taken to Cincinnati for a medical procedure. Is a procedure or an appointment?
Procedure.
The 23rd is for an appointment, an evaluation, and then she'll have a procedure later we think later in December.
Okay.
We are going to try to get it arranged telemedically on the 23rd.
I'll just provide that she may be taken to Cincinnati for medical purposes and that the agency may consent in the event parents are unavailable.
Thank you.
Okay, we'll see you back here on February 2nd. I hope there's good news this next reporting period. Thank you.
Thank you.
Okay, next up is Dominic Toll. Can I have everyone on this file identify themselves for the record?
Michael Clark, Prosecutor's Office.
Kimberly Erickson, DHS.
Rebecca McCluskey for Samantha Toll.
Ken Hotchkiss for Devin Limble.
Ivan Brown, LGAL.
Mr. Brown, how is Dominic?
Doing very well. He's with the paternal grandparents. I've spoke with them. He's adjusting very well. I am not in agreement with the recommendations. And I'm a little perplexed. This is essentially our first review hearing, and the agency is asking for discretion to go to unsupervised parenting time with mom and continue to have supervised parenting time with dad. I believe we need to treat all cases similar and be consistent. If the court will remember, when we had the trial for Mr. Lemble, Miss Toll pled no contest. I inquired as to how these significant injuries occurred to this child. The reports, none of the reports indicate how these injuries occurred, which were significant. And until I get an answer through therapy, I don't know whether Mr. Way needs to grant her immunity from prosecution. Obviously, she's not been charged criminally as of now, so most likely that's not going to occur. But before any progress can be made there needs to be some recognition how this poor child received significant injuries. And I think we're just kind of glossing over that. And to just give discretion for unsupervised without having those answers, I wouldn't be doing my duty if I agreed to that. And the only allegation which is obviously harmful is that Mr. Lembo engaged in some domestic violence, which is concerning, but how did this child get all these injuries? There needs to be some recognition and some sort of recognition in therapy and how this occurred. It's just being glossed over. Thank you.
Frankly, I share Mr. Brown's concerns. Ms. Erickson, do you have a working theory as to how these injuries happened and why we can be confident that mom wasn't at fault?
Yes, Your Honor. So while there's really no way to know exactly what happened, just from my experience in this case and getting to know Samantha and getting to know the background, I do think that she is a young mom and has had some experiences that may have that were overwhelming. And in moments of high stress with a young child, I think that could have played a large role in it. And again, while I don't know exactly what happened, from the start of the case, Samantha has been very eager to do services. Even before she was court ordered to do any, she was voluntarily participating in them, and she has completed the parenting classes. She right now is participating in individual therapy. She's participating in a supportive visitation. She's participated in parenting times. So I do think, although to this day, I don't know exactly what happened, I do think she has shown, both her and Devin have shown great participation, and she has shown that she wants to work hard to be able to be the best parent she can be.
And Judge, that's great. That's great. But without recognition, I think it's way too soon for unsupervised parenting time without some recognition as to what occurred and therapy to address that issue. How can you have therapy and not directly address the issue that brought the case into care?
I was just taking a moment to look back at the petition. Petition indicates that the marks on Dominic's back appeared to be from fingernails, which could only have happened intentionally. Do we have any information that anyone else had access to this child at the time these injuries were discovered?
Your Honor, my recollection, it's been a while since I've read everything, is that it was pretty clear that the child was in mom's care. I think she maybe was with a relative, but there was limited access to the child. And I totally understand where Mr. Brown's coming from. And I can't believe it's me, the assistant prosecutor, saying this, but I feel uncomfortable. I mean, Ms. Toll needs to discuss this stuff in therapy, but in terms of talking about it on the record, she entered a no contest plea. She has the absolute right to not incriminate herself. And so I don't know, the whole thing, Mr. Brown's suggestions leave me a little uneasy, quite frankly. Those things can be worked out in therapy, but I don't think it should be part of, we handle these cases without blatant admissions all the time. No contest pleas, the parents work out their issues in therapy. We do a psych eval, and if everyone says the kid is safe with the parent, we send them back home. And I don't think that we should treat this any differently. Thank you.
Then grant her immunity then, so she can talk about it.
I'm not going to grant her immunity just because you want her to admit what she did.
No, I want to make sure the child's safe. And without some recognition of how this occurred, how do you address it? You can't.
Let me hear from Ms. McCluskey.
Thank you, Your Honor. Ms. Erickson actually did echo a lot of my comments, so I appreciate Mr. Way's stance. It's probably one of the reasons I have a lot of respect for Mr. Way. I don't know why we continue to put my client on trial every single proceeding. She entered the no contest plea, and as Mr. Way stated, parents don't admit what could have happened at any time. This is something to be worked out in therapy. And I will note, as Ms. Erickson also stated, this client, Ms. Toll has been so cooperative and so engaged and so motivated since my first contact with her. Obviously, she engaged in services immediately, long before she was ordered to do so. And she's completed everything. She completed the psychological assessment immediately. Obviously, no missed appointments there. The only thing that came out of that was individual therapy. That is the only recommendation that came out of that psychological evaluation. And that is extremely rare, as we all know. She engaged in that immediately. The court report references that her counselor said she's active and engaged. She's actively practicing and participating in skills and techniques. She's there on a regular basis. She's demonstrating and acknowledging and understanding the skills necessary to manage and maintain her mental health. That's what we need. That's what the guardian ad litem needs, not an admission on the record what happened. And she may not know what happened. And quite frankly, sometimes our parents harm a child one time, and that gets them in this situation. That does not mean that they cannot address whatever issue led to that circumstance. Again, she's done with parenting classes. She completed those immediately. Again, she's polite, she's cooperative, she's motivated, and she's a young parent. So to continue to badger her on the record just seems wildly inappropriate. And I'm not minimizing the injuries that Dominic had, clearly, but there's no broken bones. This is not a skull fracture. These were not significant injuries. While they may look intentional, and again, not minimizing that they're injuries, this is nowhere near the most severe cases we see. So I don't know why the badgering continues. Again, and FRP has already started in the home. So we would ask that the court actually adopt the recommendations and grant discretion to return Dominic home. Thank you.
I would not be doing my duty if I just glossed over 22 separate marks and bruises on this child. Granted, there were no broken bones, and I'm glad Mom is doing wonderful. And to think that I'm badgering her, that's absolutely not the case. My position here is I am the guardian ad litem who is to give my opinion on his best interest. 22 separate marks and bruises. If I were to gloss over that, I would think the court would think that I was neglectful and not doing my duty.
Well, I would imagine that my client would sign a release so that Mr. Brown could talk to her therapist, because that would be the most appropriate way to get the answers, I think, that Mr. Brown's looking for.
That would be
in
wonderful.
my opinion.
That would be wonderful.
Let me hear from Mr. Hotchkiss.
Mayor, thank you. I can start by indicating to the court that my client has the same concerns that Mr. Brown has, and that is his child has been injured in what certainly appears to be an intentional way. This is something that occurred while in the mother's care. The mother did, pled no contest, but as the court knows, it's still treated as an admission. So the only thing that can't be used are statements that are necessary to take a responsible plea. So the court can really presume that the allegations in the petition are true. And my client is extremely concerned that the agency would even entertain the possibility of returning this child to the care of the mother. Now, as to his position in this case, the court took jurisdiction because of its concerns over some alleged domestic violence that had occurred. And I'm not going to rehash that. The court heard the evidence on that, but that was not, even though domestic violence is harmful to children, and I know this court's feelings about that, and I think they are correct. That's not what occurred in this case. There was nothing by my client that injured this child in any way. This child is currently placed with the paternal grandmother, and my client has had really substantial supervised visitation, some through the agency and then some supervised by his mother, almost 12 to 18 hours per week. And I think the placement, paternal grandmother would indicate to the court that he's bonded with Dominic, that he cares for Dominic. They have a loving relationship at this juncture. He's also concerned that the agency has not been providing services to him as quickly as he would like to engage in them. And I know that he has been on them. He's starting on parenting classes, I think, for the first time tomorrow, but he would like to get through this process as expeditiously as possible, because frankly, he believes that long-term, he is the best parent for Dominic. And I think under the circumstances, that's something that that's not unreasonable at all. My client would like me to request that this court grant the agency discretion to provide him with unsupervised visitations and even overnights, maybe at his mother's house. That would be fine as well. But there's no reason to slow my client down and then try to speed up the reunification with the really the individual who brought this case before this court in the first place. So other than those comments, my client is committed to the service plan. He will do whatever this court asks and requires of him. Thank you.
Any more comment from any of the attorneys before I rule?
No, thank you.
So it is disconcerting to the court that we're asking for mom to have unsupervised visits, or at least discretion for unsupervised visits, but we're not asking that for dad. Dad clearly had nothing to do with these unexplained injuries. I get that Ms. Toll, from all appearances, is a compliant, likable, believable person, and can be a good parent. And yet, at some point, the only conclusion the court can draw is because she couldn't calm Dominic, she lost her cool and inflicted some injuries on him. What else am I able to conclude if no one else was around the child and the child has unexplained injuries that he could not have inflicted on himself? What else am I to conclude? It's a valid concern. I get that there are occasions when parents get extremely frustrated with a colicky child that won't be consoled, and they lose their cool. I get that. That happens. We don't remove those children permanently from their parents unless there are some serious injuries involved. And I don't mean to minimize these, but they do tend to be more superficial than the kind of serious injuries we've seen, but they still indicate there had to have been a loss of self-control at some point. And perhaps in therapy, we can get to the bottom of that. I certainly want to believe that Ms. Toll, if she inflicted these injuries, is extremely remorseful and committed to making whatever changes necessary to make sure that never happens again and that her child's safe. But I also understand not only Mr. Brown's concern, but I also understand Mr. Lemble's concern that how can we ignore this? How can we ignore it? I'm not sure that giving Mr. Brown a release to talk to the therapist is going to do anything to satisfy Dad's concerns, which are well-founded. So let me ask Ms. Erickson, have you had conversations with Ms. Toll's therapist?
Yes, Your Honor. I have had a phone call and I've emailed with her. And in every referral I have made for Samantha, I have included that they address times of high stress and times where emotional control may not be so easy.
And has the therapist's comments caused you any concern at all of whatever it is that happened would be repeated?
No, Your Honor. From what it was reported to me from the therapist, she reported that Samantha participates positively, that she, as it says in the court report, that she applies what she's been learning. And it was the same through the parenting classes as well, that Samantha marked high in her assessments and that she applied what she was learning to her times with Dominic.
And let me ask you specifically why you're not asking for discretion for unsupervised for Mr. Lemble.
So far, Mr. Lemble has participated very positively. He's been eager to do all of his services. And if I may add, he has been referred to everything except for the anger management, which is in process. So he has been able to complete the psychological, participate in parenting classes, and he does very well in parenting time. However, since this position did occur about a month ago, I do feel that it might be best to give him more time working through services and working towards unsupervised visits.
So here's what I would like to do. I'm frankly ready to give discretion for unsupervised visits for Mr. Lemble. I am ready to give discretion for Mom, but only after Mr. Brown has had an opportunity himself to talk to her therapist. If Mr. Brown indicates to you, following his communication with the therapist, that he is withdrawing his opposition to unsupervised visits for Mom, then I will allow you to exercise that discretion to give her unsupervised visits.
Absolutely. Thank you.
All right. We'll set our next review hearing for February 2nd at 9:15.
If somebody would provide me with the therapist's number and name and sign the appropriate releases so I can call them, I would appreciate it.
And if Mr. Brown does object, can we have an early review hearing so we can actually discuss it rather than?
Certainly.
Okay,
Certainly.
thank you.
In any of my cases, if you ever have an issue that the court needs to address before the next review hearing, anyone can ask for an early review hearing. Okay, and I think that brings us to our post-terms. First up is Kylie Denman. If you're on this file, please identify yourself for the record.
Feisty Henry, DHHS.
Amanda Getting, adoption worker, Catholic Charities.
Ivan Brown, LGAL.
Mr. Brown, how's Kylie doing?
Wonderful. I've been to the home many times. This is a very nice family. They live in a very beautiful home. They seem very attached to Kylie. I think Kylie is really lucky to have people and been placed in this home. I am in agreement with the recommendations. Hopefully, we had a little snafu with fingerprints and a social security card, which hasn't been received yet. And typically a child has their social security card, but the child was removed right from the hospital. And I think that was no one even thought about that. So that's kind of holding things up. So hopefully we can get that social security card and get this matter finalized right away. Thank you.
I did call on Friday and they said that things have been mailed out. So as soon as I receive that, I can email to update everybody as well so we can continue with the adoption process.
Wonderful. Thank you.
As to where we are with the adoption process, on the 10/28, I was able to submit consent. So consent has been submitted. I anticipate that taking probably about 3 weeks. Once we get the social security number for Kylie, I'll be able to apply for her subsidy. The packet is all ready to go. I just need to add the social security number to that packet.
Wonderful.
So a December finalization is still possible.
I'm hopeful that towards the end of December, keeping in mind holidays and things like that. Yes.
Wonderful. We will set a review hearing, if necessary, on February 2nd at 9:15. Thank you.
Thank you.
Thank you.
Okay, Prater and Hickman minors, please identify yourselves for the record.
Sharon Arts, Department of Health and Human Services.
Rebecca McCluskey, guardian ad litem.
So, Ms. McCluskey, I did read the report. Obviously, this has been a challenging file, to say the least. And although it looks like we're finally headed in the right direction with Trenton, can you give me a report on how the children are doing from your perspective?
Well, yeah, there's kind of a lot going on here, obviously, the court just noted. So I'm glad to see it looks like we have a resolution, although I felt that way months ago. So I think it's helped that the second paternal aunt has moved into Michigan. So there seems to be some solutions there possible. So Daisy had quite a downward spiral, obviously, and the placement for Daisy and Anna Ray clearly could not handle the 3 children in that home. She has her own daughter. So it does appear, and this was kind of evident from the girls' prior placement before termination, that Daisy does respond better to a male role model. She was definitely very bonded to the prior foster father, but not to the foster mother. So this could be a very appropriate solution. I think I would support Trenton and Daisy being adopted by the paternal uncle. I think that's the best solution rather than separate all three children, but at least there's another biological relative able to take one of the children. NRA is doing very well. I think this move, I think it will be hard to be separated from Daisy, but I think it will be a positive thing for her to get the attention she needs. She's very excited. Probably disappointed now, but Anna Ray was very excited to come to the courthouse this Friday to do her adoption ceremony in person. So we're all a little disappointed that probably is not going to happen, but she's doing well. Trenton is doing better. I'm glad to see that the paternal uncle is engaging in therapy. It seems like that is actually making some positive progress. So, and Trenton obviously is now more open to seeing the uncle and even with overnights. So there's a lot of positive stuff happening, and it's happening pretty quickly comparatively to what's been going on for the past year. So the agency, everyone has worked very hard on this file. There's a lot going on. There's a lot going on behind the scenes. I think I touch this one every day, if not every other day. So it's, the agency workers have done a really nice job with a very difficult situation. So I also reviewed the court report. I had contact with everyone, and I'm in support of the recommendations. Thank you.
Ms. Ernst or Ms. Freeberg, do either of you have anything to add to your reports?
Nothing to add on my end, Your Honor, just that the agency is, we do have to redo Mr. Prater's home study, not only because his other one was over a year old, but because now it must be a home study for 2 children, male and female. And then we are also going to just kind of attack all the birds with one stone and do a home study on Melissa Beck in the event that Trenton does go there. That would be his paternal aunt, who is interested in adoption should it not go forward with Mr. Prater for Trenton. So we're kind of all just trying to move forward timely with this. But his CTAC assessment is still scheduled for tomorrow, which is positive news, and hoping we can get good results from that.
Thank you. Ms. Freeberg?
We are scheduled.
Sorry, Ms. Freeberg, I hit the ask to unmute button at the same time that you unmuted, so it ended up muting you. So if you could start from the beginning, please.
Okay. Yeah, I did see Trenton last week, and I know Miss Ernst also had a home visit at the same time. Although, you know, Trenton is disappointed with his sister needing to be placed with Mr. Prater, he was in a very good space. He was appropriate and, you know, hopeful about adoption. So we do have a meeting scheduled with all involved parties and workers this Friday to hopefully have some more updates on the assessments and placement issues.
Thank you. I appreciate the effort that you all are putting forward here. Obviously, this has been quite challenging, but I'm glad to see that we are making progress and that there are even alternative plans in place simultaneously so that we don't have unnecessary delay if there's a change. I will implement all the recommendations, and I'll set our next review hearing for February 2nd at 9:30. Thank you.
Thank you.
Thank you.
Hayden Joyner, could each of you on this file identify yourselves for the record?
Timothy Williams, guardian ad litem.
Danielle Lagore, Family Service and Children's Aid, and I'm his foster care worker.
Maria Kleckner, and I'm also with Family Service and Children's Aid as the adoption worker.
So, Mr. Williams, how is Hayden doing?
Your Honor, Hayden continues to do very well in his aunt's care. He's going to school, physically going to the building twice a week, and then doing online work. Place report any problems, so he's a joy to have. Dad still comes by every day, helps Hayden with his schoolwork. So continues to be involved in his life, and really just waiting for, the appeal decision from the Court of Appeals. And obviously we know it's going to be a little bit yet. Looks like Mom filed her brief, and I think the agency, Mr. Scortenborg, just filed their brief last week. So we're just kind of in a holding pattern to see what the Court of Appeals does.
Okay, and Ms. Kleckner or Ms. Lagore, do either of you have any updates for the court?
I do not have any updates, no.
I do not.
Very well. I will implement the recommendations. We'll set our next review hearing for February 2nd at 9:45. Thank you.
Thank you.
Thank you.
Thank you.
And next up is Brody Smith. Please identify yourselves for the record.
Maria Kleckner with Family Service and Children's Aid as the adoption caseworker.
And Danielle Lagore again as Brody's foster care worker from Family Service and Children's Aid.
Mike Kelly, guardian ad litem.
Mr. Kelly, how is Brody?
Spoke with placement, and they have no concerns. He's going to be, as the report indicated, he was attending Hillsdale County ISD in person, but they have switched him to start attending virtual schooling due to the COVID issues. Otherwise, I don't have any concerns with placement. I've reviewed the report. I have no objections to the recommendations. I'm in agreement with the ultimate goal of adoption.
Any updates, Ms. Kleckner or Ms. Lagore?
No, sir.
No updates for me.
Finalization in December still feasible?
I'm thinking so.
Yeah, that would be good. I will implement the recommendations. We will set a review hearing for February 2nd at 9:30. Thank you.
Thank you.
Last one. Okay, and finally, Noah Rogers. Please identify yourselves for the record.
My name is Ashley Beach. I'm the foster care and adoption worker for Noah Rogers.
Rebecca McCluskey, guardian ad litem.
Brad and Aaron Marwelly, foster parents.
So, Ms. McCluskey, how is Noah?
Doing very well as always in this placement. He's there are no concerns. He's growing, meeting milestones, and obviously very bonded to this placement. I've reviewed the report. I have no concerns and no objection to the recommendation. Thank you.
Any updates, Ms. Beach?
I have no changes or additions to the court report that I submitted last week. Things are going very well and are on track for his adoption to be finalized as soon as possible. There are no big barriers to finalizing. I was able to apply for adoption and medical subsidy last week, and I plan to request consent by the end of this month. So I'm hoping that I will be able to file paperwork with the court sometime in December.
That would be great. Mr. and Mrs. Marwelly, anything from you?
I don't have anything. Nothing at this time.
We're just excited for it to happen.
I'm sure you're both looking forward to it. Very well. I will implement the recommendations. We will set a review hearing for February 2nd at 9:45 if necessary, but hopefully we'll be able to get this one finalized before the end of the year. And I believe that concludes our hearings today.
I think we were doing a.
Oh, we
prelim,
do have
aren't
we do have a prelim. I'm sorry. Forgot about that.
Thank you, Your Honor.
We have that file? We do not have the file. I can pull up the petition because I know it was.
What's the file number?
I don't know. They didn't tell us yesterday. I did a removal order. Let me pull it up. At least I've got the copies that I did. Clerk's office didn't send it up.
Your Honor, I believe Shannon sent out an email yesterday saying.
Yeah, I'm aware of that, but we never got the file from the clerk's office.
And I have
So
not.
I don't have anything in front of me. Let me open up my email so that I can pull that up.
It doesn't look like it's been entered yet, Your Honor.
All right, I found. There we go. Okay, this is the matter of Clark, Marsh, and Gibson miners. And let's see, I see Michael Clark is present.
Yes, sir.
And ma'am, what is your name?
Monica.
Monica Marsh is present. And we've got someone else present. It just says 550473. I'm sorry, who's with Ms. Marsh?
Mr. Gibson.
Okay. And I've got someone in the courtroom with a number 5504373. Sorry. What is your name? Does anyone recognize her? All right. I'm assuming she's lost then. We won't worry about her. Okay. Hold on a second. I got to jump back to that other screen. So we've got Michael Clark present. We have Monica Marsh present, and we've got, let's see, Chad Gibson. Yes, and Rico Marsh, is it?
Correct, Your Honor.
He's a non-respondent.
Yes, he's also an over-the-road truck driver. So he was made aware of the hearing, but he was unable to attend due to his.
Okay, thank you. So our respondent parents are Ms. Marsh and Mr. Gibson. So, so Ms. Marsh and Mr. Gibson, you have been named as a respondent in a child protective proceeding. You are entitled to be represented by attorneys, either attorneys of your choosing, or if you cannot afford one appointed for you by the court. Would you like to have the court appoint someone to represent you this morning?
We'll be getting our own lawyer.
Would you wish to have somebody represent you just for purposes of the hearing this morning? You can always get your own attorney involved later.
You want an in-person hearing with our lawyer.
In-person hearing? I don't think they do that.
We want our lawyer that is going to represent us present.
You mean you want them here in person instead of on the Zoom?
Yes, we want an in-person hearing.
Right now, the courthouse is closed to the public. I can allow attorneys in, but I don't allow parties in. Your only mode of participation this morning is going to be by Zoom.
Okay.
So do you want me to appoint someone for just this morning until you can get your own attorney appointed?
Yes.
All right.
Okay, Judge, I don't know how to do that. I don't have a case number. I don't know who the GAL is. Whose list am I going off? Is it our case? Is it Judge ours? I don't know how you want me to do that.
Let's call downstairs and find out what's going on. What's Amanda's number?
67. Carrie Ann is 67. I don't know if they're 6761 or 6762.
6762 for Amanda Kirkpatrick.
Oh, she's probably busy with election stuff today. What's Carrie Ann's number?
I think
61. 6761.
So you sign a removal order?
Hold on a minute. I'm trying to get with the clerk's office. We're having a little trouble because we don't have a file number. Is there a general number at the clerk's office? What do people call from outside? I've got to talk to somebody.
788-426.
I would call Linda.
That's what I.
6757.
You read my mind.
That's usually who I go to for.
To get something done.
Linda, this is Judge LaFlamme. I'm trying to conduct a preliminary hearing on a child neglect petition that was e-filed yesterday, but we don't have a file. We don't have a file number. I need to appoint attorneys. It is, give me just a second, I'll tell you the name of the children. Caitlin Kinder is the worker. She said she sent it in yesterday. We have Clark, Marsh, and Gibson minors. There's actually 4 children involved. Let me ask her where she sent it. Actually, I can forward this email directly to you right now. All right, hold on. Let me get to the right screen. Forward. Linda, what's your email address? There's another Linda Salmon in the system? Oh. Oh, okay. I didn't think there was more than one of you. All right, I just sent it. I'm actually on the record right now with the parents. I can just park on the phone until you give me a file number. Shannon, who is next up for the attorneys? Let me at least indicate who they're going to be.
Who's the LGA?
Oh, we won't hear that from downstairs.
And who's the judge?
All right. That, we don't even know that.
Yeah, we don't know anything.
I did the removal yesterday, and when I went ahead and put it on my docket, and I'm actually glad I did that because Allison would be wondering what's going on right now too.
Okay.
So, Mr. Gibson and Ms. Marsh, while we're waiting, well, hold on, they're right back. Okay. I do need to advise you of some of the rights that you have in this matter, and while we're waiting for the clerk's office to get me a file number, I will do that. Can you both hear me?
Yes.
Yes.
In addition to the right to assistance of counsel, you also have the right to a trial, either before a judge or a jury if you make a timely jury demand. You have the right to appeal in order that removing your children from your care following the entry of an initial dispositional order. If your child has Native American ancestry, you, your child, and the tribe may have additional rights under federal law and Michigan law. Do either of you have, or does any parent of these 4 children have any Native American ancestry to your knowledge?
No, sir.
No, I don't think so.
Okay.
I don't.
Ms. Kinder, where are the children placed?
Alize, or they call her Allie, she is with her father, Michael Clark. Atreyu and Electra Marsh are with their father.
Okay, hold on, Ms. Kinder, sorry. Go ahead, Linda, sorry. 23557. We don't know. We're waiting for you to tell us. It would be easier if it was, but Okay. No, that's, hey, I appreciate that. Thank you, Linda. Okay, bye-bye. Okay, we finally got the case logged. The file number is 20-3557NA. It is a Judge Rapley case. Mr. Williams, who has disappeared, is the LGAL. I'm not going to be able to complete a preliminary hearing this morning. So what I'm going to have to do is adjourn this for 1 week from, well, wait a minute, is she doing?
Tomorrow.
Tomorrow.
We gotta do it in a week though, because I'm gonna have to input all this information. It's still not in the computer. I'm gonna have to do an order. I'm not gonna just throw this at them tomorrow. So if we hold the 24-hour hearing now, we still have 14 days from the prelim, so that gives us a week. We can do it in a week.
All right, Shannon's telling me we need to set the prelim 1 week from tomorrow because of the amount of time it's going to take to get all the data.
And I would call Tasha because 1 week from tomorrow is Veterans Day, so I don't know when they're doing their prelims, so I would call Tasha and see when.
I don't think they have court next week necessarily. Do you have court next week, Mike?
I have actually court this week, this Thursday.
I'm sorry, I'm talking to Mr. Kelly.
Oh.
I just don't want to set it.
I don't have anything on my schedule for next Wednesday, the 11th.
Shannon, can't we get this done today and get it on her schedule tomorrow?
Tasha. I'm not going to throw it in the docket because then I just get in the middle of it.
Well, I'm going to. What's her number?
Hey, Mike, did she schedule those for the 12th?
Yeah, she scheduled everything on the 12th.
Okay.
6, 7.
Our Wednesday is now Thursday on the 12th next week.
Oh, so you have next Thursday, Judge.
6, 8, 6, 7.
She does have court tomorrow, doesn't she?
Yes. But our next Wednesday is actually going to be next Thursday. So we do have neglects next week with Judge Rapley.
I'm going to get it done tomorrow.
Looks like a full day of trials.
Tasha, we have a petition that I'm doing a removal hearing on right now, and it didn't get processed by the clerk's office. In fact, I don't think they got it. I did the removal order yesterday. I set it in front of me. Turns out it's going to be a Judge Rapley case. What time do you want me to set it for tomorrow for completion of the prelim? 10 o'clock. That's what we'll do. Thank you. Okay, 10 o'clock tomorrow in front of Judge Rapley, and we'll complete the prelim at that time. So, Ms. Kinder, I had asked you where these children are. If you could continue with that, please.
Yes, so
hold on, sorry. Tasha? What's her extension again? She was just dialing me.
6867.
You okay? Okay. I'm sorry, Ms. Kinder. Hopefully there's no more interruptions. Please go ahead.
Thank you, Your Honor. So Miss Alizé is with her father, Michael. Atreyu and Electra are with their father, Rico and Flint. And then Kendra is with paternal grandmother, Connie Gibson.
Okay, so
I do have just one question.
is this Miss? I'm sorry. This is Mr.
Mr. Gibson.
Mr. Gibson. Go ahead with your question, sir.
Why was my daughter removed from my home?
Did you get a copy of the petition?
Yes, I did.
I-
But
It
I
says in
don't
the petition,
understand. I don't understand why my daughter had nothing to do with this. She should have never got taken.
that's something you'll be able to address with Judge Rapley tomorrow. But the reasons are set forth in the petition. I can't elaborate on them because I don't know any more than what's in the petition. But you
Thank you, Your
will
Honor.
you will have an opportunity for a hearing tomorrow. Court-appointed attorneys will be present who will be able to advise you if between now
My
and
civil rights
tomorrow.
were violated.
That will be addressed tomorrow as well, sir.
Yeah, you guys are under violation of 1983, the due process violation under section 1983 of my civil
All right,
rights were violated.
you can tell Judge Rapley about that tomorrow. Let me finish what I was saying. There will be court-appointed attorneys present tomorrow who can represent you then. If you do want to hire separate counsel and you're able to do so between now and tomorrow, they could certainly appear in front of Judge Rapley. But if you can't do that this quickly, that's understandable. Judge Rapley will appoint attorneys who will be able to consult with you privately. We have the ability to put you and your attorney into a separate meeting room so that you can have a conversation about this before you proceed with completing the hearing. You will have an opportunity tomorrow, if you choose, to admit, deny, or offer an explanation to the petition. Judge Rapley will be able to address any legal issues that you raise as a result of that. So save your questions for her because she's the one that's going to be presiding over your case.
All right, thank you.
All right, 10 o'clock tomorrow. Thank you all. That
Thank you,
concludes
Judge.
our court session today. Have a good day.